I am Katie O'Connor. I'm the Director of Policy Development and Programming at ACS in DC. I want to thank Tom again, and thank you again to McKenna Long and Aldridge for hosting us today. I'm going to go ahead and invite the first panel to come up and have a seat. And while I do that, I'm going to introduce the moderator, Ari Berman. Ari is a contributing writer for The Nation and an investigative journalism fellow at the Nation Institute. He has a new book coming out in August, so add it to your Amazon list. It is about the history of the Voting Rights Act since 1965. The title is Give Us the Ballot, The Modern Struggle for Voting Rights in America. Ari has also written extensively about American politics, civil rights, and the intersection of money and politics. We are happy to have him here, and Ari, the floor is yours.
Thank you, Katie. Everyone can hear me, and thank you for all being here. I'm told that usually there is a beautiful view in this room, and that you can see for many miles, but I kind of like being enveloped in fog. It feels like we're discussing voting rights in Middle Earth. And so we'll just have to enjoy the ambiance for what it is. And as Katie mentioned, my name is Ari Berman. I cover voting rights for The Nation magazine, and I am thrilled to moderate this wonderful panel with people that I've learned so much from over the years, and to talk about something that is very pressing today. Franita went to the bathroom, she'll be back in a second, so for now I'm going to introduce Dale, who is on my far left. That's a geographic statement, not a ideological statement, but Dale is director of the Voting Rights Project at the ACLU. He is litigating many cases currently in states like Wisconsin and North Carolina, and you probably from time to time see him on MSNBC. To my right is Josh Douglas. He is, let me grab your official title. He has a very long official title that he said I should definitely read. So Josh is the Robert G. Lawson and William H. Fortune Associate Professor of Law at the University of Kentucky College of Law. He is a rabid Kentucky Wildcats basketball fan and says anyone who didn't pick them in their bracket is crazy. To his right is Anita Earls, Executive Director of the Southern Coalition for Social Justice, who has done so much amazing work on voting rights in states like North Carolina, where she is from. She told me that she taught at Duke and UNC, and her son goes to NC State, so she is agnostic about who to root for in this year's March Madness. And to my left is Franita Tolson, who is the Betty T. Ferguson Professor of Voting Rights at Florida State University College of Law, and she told me before the panel that she is the queen of obscure constitutional provisions. So you should be sure to grill her on that later. And I just want to give a quick overview of where we're at right now in voting rights, and then kick it over to the panel who knows a lot more than I do about this subject. But as Tom alluded to earlier, since 2011 we've seen a wave of attempts to make it more difficult to vote. From 2011 to 2012, 100 new voting restrictions were introduced in 41 states, with 19 states adopting laws to make it more difficult to vote, ranging from strict voter ID laws in places like Texas and Wisconsin, to cuts to early voting in states like Ohio and Georgia, to shutting down voter registration drives in Florida, to disenfranchising ex-felons in Iowa and Florida. So all across the country we've seen attempts to make it harder to vote. Obviously, a lot of these laws were blocked on a temporary basis during the 2012 election, but then came the Shelby County decision, which Tom talked about, striking down the requirement that states with the worst histories of voting discrimination, like in Georgia, had to approve their voting changes with the federal government. And so what we're seeing in the wake of that decision, which we're going to talk more about on the panel, is that very restrictive new laws are going into effect in states like Texas and North Carolina, and that it's much more difficult to challenge them now. And I crunched the numbers fairly recently just to get the overall picture of voting rights in the last few years, and I've found that from 2011 to 2015, based on data from the Brennan Center for Justice, 395 new voting restrictions were introduced in 49 states over the last 4 years. So this debate has occurred in every state in the country virtually. and that half the states in the country have passed laws making it more difficult to vote, north and south, east and west alike. So this is really now a very disturbing national trend. And that segues into our panel, because with there being a serious retrenchment in federal efforts to protect the right to vote, state courts and state constitutions become more important than ever. And I want to start with Josh, because he has written a wonderful article about this very topic called The Right to Vote Under State Constitutions. And Josh, you make a very fascinating point that every state but Arizona explicitly guarantees the right to vote under their state constitutions, in contrast to the federal constitution. So if you could please lay out for us what the right to vote guarantees are under state constitutions and why they're being so underutilized today.
Sure. Thank you, and thanks to ACS and to all of you for being here today. I think it's really important that we have this conversation and that it continues. So, as most of you know, and as Art just said, the U.S. Constitution does not explicitly grant the right to vote. The U.S. Supreme Court has seen the right to vote in the negative. Well, the constitutional amendments all talk about in the negative, say no state may deny the right to vote on the basis of certain criteria such as race, sex, etc. But it doesn't actually say that their right to vote is conferred anywhere. And in fact, the U.S. Supreme Court has explicitly said that the Constitution does not grant the right to vote. Only that once a state does so, it has to do so on equal terms. But state constitutions, as Art said, actually do affirmatively and explicitly grant the right to vote. And they do so in clauses that say things like, all voters of the state shall be qualified electors, or shall have the right to vote, or are electors of the state. And they do it with, some states do so with a couple qualifiers. They say, all citizens of the United States who are residents of the state and 18 years of age shall be qualified electors. So they often put some qualification criteria on the provision of the right to vote. And some states also include felon disenfranchisement or mental incapacity in their constitutions and take that away, have exceptions to the grant of the right to vote. Beyond that, though, every state, besides Arizona, explicitly in their state constitution says the citizens of the state shall be qualified electors or shall have the right to vote. Arizona is strange, and I tried to trace the history as to why it didn't include it, because Arizona and New Mexico's constitutions were ratified at the same time, and I couldn't find, there's no good reason. But I think it's okay because the Arizona courts have construed a different provision of its constitution, one that says that elections shall be free and open, and it said that that free and open provision, it basically confers the right to vote. So I think we can safely say that all 50 state constitutions provide protection to voting that goes beyond the U.S. Constitution. Now this is important because of the way in which state courts are construing these state constitutional provisions. A lot of courts, when faced with challenges, and although challenges had been few up until recently, there have been more and more challenges under state constitutions, including by some of the individuals, brought by some of the individuals here on the panel. So it's been an increasing source of litigation. But a lot of state courts, when faced with these constitutional challenges, do what's known as lockstepping. That is, they say, we've got our state constitutional provision, here's what it says, but we're going to read it in tandem with the corresponding provision of the U.S. Constitution. So we're going to lockstep our state constitutional protection to the U.S. Constitution's protection. And so with respect to voting rights, it says, well, the U.S. Constitution, under the Equal Protection Clause, the Supreme Court has protected the right to vote to this level, and these are the tests that it has applied. And so we're going to do that, the same exact thing for our state constitution. Now, I think this is dangerous for many reasons. One of which is that state constitutions and the U.S. Constitution are textually different. The U.S. Constitution does not explicitly say that there's a right to vote, while the state constitutions all do. So just from a textual perspective, we should read those state constitutional provisions more broadly. In addition, this is, I think, something that Franita is going to talk about. Article 1, Section 2 of the U.S. Constitution defines voter qualifications, defines who may vote in federal elections, and it does so by references to the states. It says whoever can vote for state legislature can vote for the federal legislature. So instead of the state constitution following the U.S. Constitution, this should actually be the other way around. The U.S. Constitution follows the state constitution, and the state constitutions are broader. Now, where we've seen some success in the states on things like voter ID laws is where a court does not do the lockstep analysis and independently analyzes its state constitutional provision to be broader than the U.S. constitutional protection. I think that's the right approach. So if we understand what's in the state constitutions and how they're broader than the U.S. Constitution, and don't just follow the U.S. Supreme Court's lead in construing them, then I think we'll get a lot of success on protecting the right to vote.
Thanks, Josh, and we'll come back to you for a lot more specifics on the issue. And I want to turn to Franita next, because Franita, you've also written a very interesting law article in the Boston College Law Review, Volume 56, Issue 1, called Protecting Political Participation Through the Voter Qualifications Clause of Article 1. And so can you talk about, we were talking earlier and you said in the 1960s courts looked very closely at state voting laws, but they've gotten away from doing that. Can you talk about why that is and how we could change that?
So the 1960s, we kind of look at that as the high water mark of voting rights, right? We had Harper, you had Reynolds versus Sims, the one person, one vote cases. We really did have a situation where the court was very proactive in protecting the right to vote. And it's just very interesting how the court has gotten away from that to now it applies a very deferential balancing test to state election laws. And the sad thing is Harper kind of laid the groundwork for some of this, if you think about it. If you read the decision, what it does is it recognizes a fundamental right to vote in federal elections under Article 1, Section 2, which, as Josh mentioned, is a provision that basically ties the qualifications for federal electors to those who are qualified to vote in state elections. But then it looks to the Equal Protection Clause to find a corresponding right to vote in state elections. And the odd thing about this setup is that the Equal Protection Clause, so the court says, well, look, you know, states don't have to extend the right to vote, right? But if they do, they have to do so on equal grounds. And it's really odd to think about something that's fundamental that can just be taken away, right? So number one, you kind of like, okay, even though I like this decision, we're in a land of strict scrutiny, but it's just a very odd decision conceptually. Well, also, if Article 1, Section 2 creates a right to vote in federal elections that's fundamental, then doesn't that mean that the corresponding right to vote in state elections must exist if the qualifications in both are tied together? So it seems like it would have been easier for the court to just simply say that Article 1, Section 2 recognizes both. So why does that matter today? Well, it matters because the Equal Protection Clause has become the dominant framework for assessing regulations, regardless if they apply to state elections or federal elections. And so if the framework is one in which allows a state to withdraw the right to vote if it chooses, then of course the courts turn to say, okay, well, we're going to give states a lot of room to regulate the right to vote. It gets away from the fundamental nature of the right to vote as recognized by Article 1, Section 2. So conceptually, Harper, even if you agree with the outcome, is a weird case, and I believe it sort of laid the foundations for the very deferential approach that the court applies today.
Great, thank you. So I want to ask questions to our two active litigators on the panel, and they are both very active litigators, and so we want to get some of their real-world examples. But Dale, the issue of voting rights came before the Supreme Court in the 2012 election, in the 2014 election, I should say, on 4 different cases, from Ohio with regards to early voting, from Wisconsin and Texas with regards to voter ID, and with North Carolina with regards to same-day registration and counting of out-of-precinct ballots. And in 3 of those 4 cases, the Supreme Court declined to block restrictive voting laws. So can you talk about the impact of those decisions, how that's changed your strategy going forward in terms of litigating under state courts, and then after you do that, talk also about some of the successes in litigating in state courts in Arkansas and Pennsylvania.
Sure, I'd be happy to do that. Thanks a lot, Ari, and thank you all for coming today. It's a privilege to get a chance to talk to you about some of the work that's being done in this area. So, as Ari referenced, I want to talk a little bit about what happened in voting litigation in the run-up to the 2014 election, and in particular to contrast what happened in federal courts, where the results were decidedly a mixed bag, with what happened in state courts, where we seem to get, anyway at this point, a series of unequivocal victories that eluded us in federal court. So Ari made reference to a number of federal cases. I want to talk briefly about 3 of them that made it to the Supreme Court on emergency motions prior to the November election last year. The first case that reached the court was a case from Ohio that the ACLU was litigating that involved a few different things, but most significantly it involved cuts to early voting in Ohio, cuts to the first week of early voting, weekday evenings of early voting, and weekends. These were days and times on which over 120,000 people cast their ballots during the 2012 presidential election. We brought a challenge to this under Section 2 of the Voting Rights Act and under the Equal Protection Clause. We won a preliminary injunction in the district court, which essentially, from our perspective, preserved the status quo in Ohio, did nothing more than require Ohio to maintain early voting at the same hours and times that it had done in the previous 3 federal elections. We faced an expedited appeal to the Sixth Circuit, where we again prevailed unanimously, a 3-0 decision upholding the preliminary injunction. And then the state sought an emergency stay of that ruling in the United States Supreme Court, and 18 hours before early voting was set to commence in Ohio, the Supreme Court, by a 5-4 decision, stayed the Sixth Circuit's ruling, essentially permitting Ohio to close its doors to voters the following morning. This, I have to say, actually came as something of a surprise to us. There was similar litigation around early voting in Ohio before the 2012 presidential election, really about the last weekend of early voting in Ohio, and the Supreme Court declined to get involved in that case on an emergency basis before that election, and we thought the same sort of thing would happen here. When you think about the standard that a party has to meet in order to obtain a stay of a lower court ruling, too, it was hard to, I think, ahead of time, understand how the state could have prevailed here. The standard that one has to satisfy to get a stay is similar to a preliminary injunction standard, which means that one of the things you have to demonstrate is irreparable harm. Right? So the state of Ohio had to show that they would be irreparably harmed by having their doors open to voters 18 hours from then. And what's really interesting about Ohio early voting, as opposed to some other states, is that Ohio doesn't have satellite early voting locations. Some states have early voting locations at a number of different places. Ohio doesn't do that. The only place you can vote early in Ohio is at the County Board of Elections office, which was already going to be open that day, right? All we were asking was for the office, while it was open during its normal business hours, to not just only conduct what it was planning on doing, but also to accept ballots from voters who sought to cast a ballot that day. Supreme Court decides that is irreparable harm to the state of Ohio. I don't, maybe it has to do with the dignity of the state and hurting the state's feelings, but as Tom alluded to in his opening talk. But we were caught off guard by this, quite frankly. A second case from last year, North Carolina, right? This case is a case we're litigating with Anita, and involved a number of different changes to North Carolina's early voting voting laws, one of which is the practice of same-day registration. There are about a dozen states in the country that allow you to register to vote and cast a ballot on the same day. Those states, on average, have turnout rates that are 10 percentage points higher than the states that don't have same-day registration. So we know it's very significant, right? In 2012, 90,000 people cast their ballots in North Carolina using same-day registration. This is, again, something that the state sought to eliminate, like in Ohio with some of its early voting period. We challenged this. It sought a preliminary injunction to block that before the 2014 election. We weren't successful in the district court, but in the Fourth Circuit, we were successful by a 2-to-1 vote. We got a ruling that, among other things, required North Carolina to maintain same-day registration as it had during the previous 3 federal elections. Okay, we thought, what happened in Ohio wasn't great in the Supreme Court, but, maybe we have a shot here, particularly given the stench of what happened in North Carolina. If any of you are familiar with the timeline there, it's really remarkable what they did. We can talk about that a little bit more in a second. Again, the state seeks an emergency stay, and again, the Supreme Court grants it. Okay. Third case, Wisconsin. Right? It stays ugly. Okay? So this is a case where we challenged that state's strict voter identification law. The trial court in that case found there were 300,000 registered voters in Wisconsin that lack one of the forms of ID that is required in Wisconsin to cast a ballot. We went up to the Seventh Circuit. The day before oral argument, the state of Wisconsin announces that it's going to have newer, relaxed procedures that purportedly make it easier for people to obtain IDs. Right? This is the night before oral argument. They submit it to the court. The Seventh Circuit stays the district court's injunction, which had blocked the voter ID law. We pointed out, subsequent to that, to the Seventh Circuit, that voting had already started in Wisconsin. Over 10,000 absentee ballots had been mailed out to voters and without instructions, notifying those voters that they would have to include ID. Hundreds of those ballots had already been returned without ID. The state was now going to require all voters in the election to submit ID, so hundreds of voters who had already cast their ballots would be disenfranchised. The state was changing the rules of the election in the middle of an election underway. We pointed this out to the Seventh Circuit. Seventh Circuit deadlocks 5-5 on en banc rehearing, leaving the earlier ruling in place, right? Too bad, so sad. You've cast your ballots, you're going to be disenfranchised. Fortunately, however, the Supreme Court stepped in, right, and vacated the Seventh Circuit's stay, which left the district court's injunction in place for the November election. So Wisconsin's ID law not implemented for the November 2014 election. But when you look at the big picture here, very, very mixed bag that we got in federal court. Now, obviously, none of these cases, or none of these decisions were rulings on the merits from the Supreme Court, right? And all of these cases are continuing to be litigated. But I think it's hard when you look at the big picture to not detect some hostility to our position, either from the Supreme Court or from other courts. So with that in mind, we look at how litigation in state courts went in the run-up to the 2014 election. And I'll be brief, but we challenged Pennsylvania's voter ID law in state court. We won, the state didn't appeal. Complete victory. Arkansas, we challenged that state's strict voter identification law. Unanimous, 7-0 victory in the Arkansas Supreme Court. Again, complete victory. Iowa, we challenged voter purges in that state, which we asserted were improperly implemented without going through proper administrative procedures, and which were erroneously purging duly registered and eligible voters from the rolls. Again, we won that case in the lower court, and the state eventually dropped its appeal when the case was pending in the Iowa Supreme Court. So when we look at this landscape, it's hard not to be tempted, from my perspective as a litigator, to start thinking about whether or not it makes sense to shift our strategy a little bit more towards state court. Now, there are obviously limitations with that kind of strategy because the state courts aren't hospitable everywhere. Particularly, they're not always hospitable in places that are implementing these strict voter restrictions. I wouldn't want to go next door to Alabama, for instance, I think, and try my luck in that state's state voting system. But
I want to go before Roy Moore.
Maybe not. But it is changing the way that we think about what the best fora might be for these kinds of challenges. But with that, I'll turn it over to Anita, or back to Ari.
Thank you, Galen. Anita, you have a slightly different perspective in that you were saying that state courts can be as political as federal courts. So can you talk about that, and then also about your experience litigating in state courts in states like North Carolina, Florida, and Tennessee?
Yes, thank you, Ari. I'm really excited to be here today, and I have to say it's so heartwarming to look out and see so many colleagues. I'm a little bit humbled because I'm speaking in front of Jerry Wilson, who was a board member of my organization and he's in the back there, but many of you probably know him as a longtime voting rights advocate. He worked with me on my first voting rights case in the 1980s. But also here, of course, is Lachlan McDonald, who is the voting rights attorney that all of us aspire to be in terms of his steadfast, brilliant advocacy over so many years. So there's enormous, and I haven't named everyone obviously, but there's enormous resources in this room, in the state, in the Southeast region. So that's wonderful to see, and I hope we can build on that. I do get to talk about some of the battle scars because our state court cases have had mixed results. We have been litigating a redistricting case in North Carolina, which we filed in 2011 in state court, with a strategy that while you might typically not think that a redistricting case should be in state court, we had some state constitutional provisions governing redistricting that we felt the legislature had so clearly violated. Things like a whole county provision, they split more counties than you needed to. The state constitution says you're not supposed to do that. We thought that our court would hold the legislature to the state constitution. But they haven't, they didn't. And we have in North Carolina, we have other ways in which our state constitution has been interpreted to be stronger than federal guarantees. So on things like, does the one person, one vote requirement apply to judicial districts? At the federal level, there's been kind of a conclusion that judges are not really representatives, so you don't necessarily have to have districts of the same size. Our state courts said, no, we think you should have closer to same size judicial districts. On the question of whether multi-member districts, if you have a plan that has both multi-member districts and single-member districts, does that violate equal protection in some way? Our state courts have said, yes, it does. Under the state equal protection clause, you can't have a system that has some multi-member districts and some single-member districts, even though you might have equalized the populations. And there have been explicit statements in state Supreme Court opinions saying we're strict about equal protection in North Carolina. And I think there are other state constitutional decisions likewise that have opened the door to theories of why the state constitutional guarantees should be stronger than federal court guarantees. We also lost in Tennessee state court. There it was a one person, one vote challenge to Tennessee's Senate redistricting plan. Basically what they did was overpopulate the Memphis district, which then effectively diluted the voting strength of African American voters in that region of the state. And there was strong prior state court decisions saying that even though Tennessee has a whole county provision, we understand that the federal constitutional one person, one vote criteria is more important, and that has to be strictly adhered to. And then in this time around, they said, oh, we've changed our minds. I really think I commend Professor Douglas's article to you because there's a really fascinating discussion about the politics of judges in state courts and how does that play out in voting rights cases. But I would just suggest 4 considerations when you're asking the question, should we bring this case in federal court or state court? So should the case be brought in state court? First, I think you have to ask on behalf of your clients, what is the political orientation of the judges, and if they are elected judges, the electorate that's electing them. Just to give you a couple of examples from North Carolina why that ended up hurting us. We have a state Supreme Court that is elected, and after we filed our case, we had elections for that court. We had initially won an important motion in the trial court about discovery of legislative documents, and we were going to get a bunch of material that would help us prove our case, basically. That went up to the state Supreme Court. We filed a recusal motion because one of our justices, Justice Newby, there had literally millions of dollars, over $2 million had poured into the state to support his reelection on the message that if we don't get him reelected, we'll lose our redistricting plan. So it was tied very closely to our case. And we felt we had better facts than the Caperton case, the Caperton versus Massey Coal Company case in the Supreme Court about when you can recuse judges when there's a conflict of interest based on expenditures in their elections. The state Supreme Court denied that recusal motion without opinion or comment. And the other thing that happened to us with judges in that case was that then when we get back in front of, we had a 3-judge panel because it was a redistricting case under state law that establishes that. One of our judges, our Superior Court judges are elected, about a month before our trial, suddenly appeared in an appropriations bill, a motion that would essentially strip her of her seat as a resident Superior Court judge in her district. And we know that she was aware of this and not very happy about it, but the politics of who controlled the legislature and who controlled her seat as a judge were surrounding the case. So we ultimately ended up with a decision that said that it was a racial gerrymander, the district, because we had race claims as well as state constitutional claims, but that it passed strict scrutiny, and we are now ultimately seeking cert in the Supreme Court. But so political orientation of the judges and the electorate that elects them, or the people who sort of hold power over them, is a number one consideration. I secondly think how factually complex is the case, and can you get a state court judge who will delve into the facts? If it's not factually complex, should this precinct stay open longer or some other pretty basic fact? I think state court's a strong candidate, but state court judges, not all of them, not exclusively, but it may be harder for them. They don't have clerks in the same way. It may be harder for them to exhaustively consider all of the details of a really factual, complex case. So that's another consideration. Then third, the governing legal standards. Are you primarily wanting your case to be a state law case? Do you have good state constitutional claims? Or is this really a federal case, like 99% a federal case? Out of Virginia, I've seen really good trial court judges understanding scrutiny, understanding that racially polarized voting has to be legally significant in order to justify race-based redistricting. They can get these really complex issues that they probably don't see as often. So some judges can, but not all, I would submit to you. So how complex is the governing standard? Are the governing standards you're going under, and is this primarily a state or federal law case? And then finally, timing. Can you get a quick win at the state court level that will ultimately accomplish what you want and have beneficial results? Or do you have the potential of the state court dragging their feet? In our redistricting case, we argued our appeal in the state Supreme Court in January, and they didn't rule until December. And I just don't think a federal court would, even if they're going to rule against us, they wouldn't do that to us. I think timing is critical in voting rights cases, and so it can cut either way, but that's the fourth consideration I would suggest.
Anita, I want to stay with you for a second because, as Dale mentioned earlier, North Carolina in many ways is now at the epicenter of the debate over voting rights because so quickly after the Shelby County decision, days after the Shelby County decision, the North Carolina legislature took a relatively modest voter ID law and essentially passed a 57-page bill that repealed or curtailed nearly every reform in the state that made it easier to vote over a period of decades. And so it was really the most clear demonstration of the impact, the immediate impact of the Shelby County decision. That case, parts of that case were challenged in the preliminary injunction, as Dale mentioned. Then there's going to be a full trial this summer about all the provisions of the law, but you are challenging the voter ID provision specifically in state court as well. So can you talk about how the voter ID lawsuit will be different in state court and why you went that route and what you're going to be challenging?
I think that we concluded that because of the numerous interests that we're willing to litigate in North Carolina, that we could be in both venues. And that on the voter ID question, we do have in the state constitution a qualifications clause, and so we do have an argument that the legislature does, that by implementing a strict voter ID requirement and barring people who don't have an ID from being able to vote, we don't have a signature alternative. I think that's a crucial distinction when you're talking about voter ID, but we have no path to voting other than absentee ballot for people who don't have IDs or don't have birth certificates and can't get IDs in North Carolina. That kind of absolute bar creates a qualification to vote. And so we have a state clause that says the only qualifications to vote are a citizen and a resident and 18 years or older. And so we have an argument that if you're going to add the qualification that you have to possess a photo ID in order to vote, that has to be by constitutional amendment, not by the legislature. We anticipate that we'll have slightly different evidence than what's in the federal case in terms of some of the expert testimony and some of the theories that we hope our state court judges will be open to. We were fortunate, I think, to get a very good state court judge. We still have that Supreme Court up there. But so I think right now at the trial court level, if you had to say, do we like our federal judge better than our state court judge? Right now, the answer is the reverse. I mean, we have a state court judge who understands the types of barriers that people of color, people with disabilities, people of limited means, he understands those kinds of barriers and is willing to credit evidence and testimony about those and understand the implications for democracy. So that's, that was our goal, was to actually try to be in both forums.
Anita, I want to stick with the voter ID for a second, because Anita supplied a very interesting chart about recent court rulings on voter ID laws. Katie, has that been passed out to everybody? It's over there? Okay, so I'm just going to quickly summarize it and then ask the panelists to talk about this. I think there's a common misperception that the entire debate about voting rights is about voter ID laws. Clearly it goes well beyond that, but I want to stay with voter ID for a second because of this chart and because a bunch of these cases have been litigated in state court already. So based on Anita's findings, state voter ID laws have been declared unconstitutional in Arkansas, Missouri, and Pennsylvania. But they've also been upheld as constitutional in Georgia, Indiana, Michigan, Tennessee, and Wisconsin. So I want to open this up to the panel. Can one of the panelists talk about why state courts in different states have ruled differently on voter ID laws depending on the state? Josh, since you've researched this.
Yeah, so I think this goes largely in almost every one of those examples to the way in which those courts have construed their constitutional provisions. The one that Anita just talked about in North Carolina. Again, they're, while not identical, they're basically all the same across all 50 states, where they say citizens shall have the right to vote, subject to only a few qualifications: citizenship, residence in the state, and age. And so the Missouri case from 2006, this was even before the U.S. Supreme Court's decision in Crawford, which upheld Indiana's voter ID law under the Federal Equal Protection Clause. In the Missouri Supreme Court in that case in 2006 said, basically, look, our Constitution goes further than the U.S. Constitution. It provides only this list of qualifications that the state may impose on voters, and a voter ID law, because it's not universally possessed, it's not everyone has it, and there's no other alternative like a signature requirement, that is an added qualification that goes beyond what the state constitution allows. The Arkansas Supreme Court in October 2014, right before the November elections, had a very similar analysis, said our state constitution goes beyond the federal constitution, and so this addition of a voter ID requirement, which not everyone can satisfy, goes beyond the state constitution's provisions, or is contrary to the state constitution's provisions of voter qualifications. And in fact, Wisconsin, one of the cases you mentioned, that litigation went through the whole stages of litigation, and trial courts there had I think a great line that the trial court, which struck down the law, said, we are not. This is not the U.S. Constitution, and so we're not going to follow the U.S. Supreme Court's decision in Crawford, which upheld the law under the Equal Protection Clause, because our Constitution says something different. However, the Wisconsin Supreme Court basically said, we're going to follow Crawford, the U.S. Supreme Court's decision, and the Tennessee Supreme Court basically said, we're going to follow Crawford. The Georgia Supreme Court actually tried to say, well, we're not going to exactly follow Crawford because our Constitution does go beyond the U.S. Constitution. But then its analysis functionally was following Crawford. So although it tried to disclaim doing this lockstep approach, I think it actually did so. So to me, the distinguishing factor, by and large, has been whether the state court is willing to properly read the state constitution as going beyond the U.S. Constitution. When it does so, it's been striking down most of these laws. And when it says, no, we're going to lockstep and follow the U.S. Constitution or follow Crawford, then it's upheld these laws.
Franita, how has the Shelby County decision forced voting rights advocates to look for other solutions, and to what role can state constitution and state courts fill the void?
So Shelby County, for all of its bad parts, I think one thing it does do is it forces voting rights advocates to be more creative, right? And so I don't think that you would have seen, the really creative use of Section 2 of the Voting Rights Act that we've had recently to attack some voter identification laws if Shelby County hadn't been decided. Because of course, although Section 5 only applied to southern states, and Section 2 litigation tends to be, as the speaker pointed out this morning, tends to be very burdensome and very costly, it really has forced us to look at different provisions and different uses of provisions and trying to figure out how we can approach these laws. And so I know in the legal scholarship, me and Josh in particular have used Shelby County as an opportunity, right? So my arguments about Article 1, Section 2, it's not that these are new arguments, right? Harper itself, you look to Article 1, Section 2 as a foundation for the right to vote in federal elections. It's just that Shelby County now provides us with an opportunity to revisit some of these provisions. Recently, I've written about Section 2 of the 14th Amendment, which most people are like, what's that? Because the focus is usually on the Equal Protection Clause. But Section 2 allows Congress to reduce a state's representation in the House if they abridge the right to vote. And it's not based on race, right? It's a very broad and open-ended provision that allows Congress to reduce a state's representation. And in my scholarship, one thing I argue is that Congress, under this provision, is not limited to just reducing a state's representation. And in fact, this can be another provision that we rely on to protect voting rights. And so I think one upside of Shelby County is that it's forced us to look to other provisions, and it's also brought renewed attention to state constitutional provisions. And so in essence, my argument, many of them are based on this idea that state constitutional law should drive the scope of both state and the right to vote in both state and federal elections because of Article 1, Section 2. And I don't think that, had Shelby County been decided, I don't think that I would have looked at Article 1 and Section 2 as a new source for protecting the right to vote. So really the decision has sort of refocused attention on other provisions, both state and federal, as ways to protect the right to vote.
I should also mention that The Nation, putting in a plug for my own publication, ran a very long article about Section 2 of the 14th Amendment earlier this year. Dale, I want to go to you because Anita mentioned 4 considerations in terms of whether to go to state or federal court. You've gone to both state and federal court recently, so can you talk about when you're thinking about filing a case, the upsides and the downsides of state court? On the one hand, in places like Pennsylvania, we've seen very impactful state court decisions striking down things like voter ID laws. On the other hand, they don't set a precedent elsewhere. So can you talk about your choice in terms of where to file lawsuits?
Sure. And I'd say I agree with everything that Anita said in terms of what criteria we and everyone should be taking into account when deciding between whether to litigate in federal and state court. And if I can harmonize what Anita was talking about, what Josh was describing as the methodological differences between those state courts which have found expansive protections for voting rights under state constitutions and those that have not. I think, unfortunately, the choice of interpretive method probably doesn't precede the outcome in these cases. That is, I think that these courts are unfortunately more outcome determinative than that. When they choose their methodological mode of interpretation. So, as a voting advocate, I'm very saddened, I think, to report that these issues have become highly partisan and politicized, right? And I think what that means is that if you have a court that's going to be favorably disposed towards you in terms of the outcome that you're seeking, then they will choose the interpretive method that lends itself to that. That is, they will not lockstep their state's constitution with the more meager protections of the federal constitution in terms of voting rights, but will be more inclined to find an expansive protection under the state constitution. If you have hostile courts, then they are going to do the opposite. So what do we look for? We try to look for, obviously, as Anita pointed out, trial-level judges who are going to be very, very attentive to the facts, but also state courts of last resort that we think will be favorable for us. And it is unfortunate we cannot leverage those victories in a particular state Supreme Court to guarantee outcomes in other states, as evidenced by the very, very different outcomes that you've seen in different state courts.
If I can jump in, I'd say I actually do think that we are going to made use of the, Arkansas decision in our voter ID case. So I think the article actually also does a good job of making the point that state courts, and especially state Supreme Courts, are going to be you can use the other states' decisions in your arguments to them. So I think it's not the same thing as winning at the U.S. Supreme Court and automatically deciding it for the whole country, but I do think that there's impacts and influences beyond the single state. And I also want to just give an example of what I'd call a subsidiary consideration, but we did have a victory in state court in North Carolina over an issue of whether an early voting site should be located on Appalachian State campus, a college campus in Western North Carolina. It was the kind of case where it was almost, did you really want to go to federal court over that? No, but we could get a Superior Court judge who found that the decision to close that early voting site was intentionally discriminatory against students, and ordered the local board to keep it open. So you can find courageous state court judges in discrete cases and make a difference for people.
I want to open it up for questions in a second, but Josh, you had a point you wanted to make, and then I want to ask you a question.
Yeah, so actually two very quick follow-ups to some of the things that were said here. One of which is, I think I shared Dale's concern about the outcome determinativeness of these cases. However, one thing I've looked at actually in some preliminary research is whether the partisanship of the judge and whether the judge is appointed or elected makes a difference in the interpretive method. And not surprisingly, I found in my survey, the survey of cases, that the more liberal-leaning or Democratic-leaning judges are more likely to construe their state constitutions more expansively, which is actually a little bit backwards if you think about it, because you think conservative judges who might have more federalist ideals might want their state constitutions to be paramount, but it goes the opposite way. The other thing that I was not expecting, but what I find very interesting, is that it tends to be that appointed judges seem to do better about ruling their state constitutions more expansively than elected judges. And we see this most poignantly in issues that have political ramifications like felon disenfranchisement. There have been some successful litigation in state courts that cut back on the state's felon disenfranchisement laws, and those cases tend to see the constitutional protections more broadly and tend to be written by appointed courts instead of elected courts. The other thing I want to follow up real quick on the other point is that the other interpretive method that we see is that there's a lot of deference to state legislatures in enacting these laws for courts that rule narrowly on the right to vote, which is actually backwards from what heightened scrutiny is supposed to do. The state's supposed to justify and have a reason. So for voter ID, the state just says election integrity, and both federal and state judges often will say, well, that's enough, without proving anything more specific. And so another argument to be made is that it's improper to defer so readily to the state legislatures, and that we should hold them to the requirement of actually justifying their election regulations.
Josh, you wrote another interesting article called "State Judges and the Right to Vote." And do we know where that's going to be published?
Not yet. Any law reviewers out here that want to publish it?
Okay. Well, anyway, if anyone wants to read it,
it's out soon. It'll be placed soon.
It's on SSRN if anyone wants to read it. But you make the point that if we want to use state constitutions and state courts more, we have to know more about the courts. And basically the public has no idea who their state court judges are. Most of them are very obscure. And Anita, one of the things that happened with North Carolina's voting law is the legislature repealed public financing of judicial elections. And so those elections are now going to be more politicized at a time when the courts are going to be more important. So Josh and any other panelists want to talk about both how we can draw more attention to state courts so the public is more engaged on the issue, but also how we can try to ensure the integrity of the judges in those states where judges are elected on the state level.
I guess I'll start in that, and I mean it is fascinating. Just look at media coverage of exact same cases. The Wisconsin voter ID case is a good example. When that was going through the federal court system, there were tons of national stories involving the case. But as it was going through the state court system, the only media I could find about it were local papers in Wisconsin that covered it. What we can do to fix that is what we're doing today, and continuing those kinds of efforts to really demonstrate how state judges decide way more election cases and voting rights cases than federal judges do year to year. It's just that the federal ones get more prominence. And so continuing the conversation among people who care about this issue is at least a good first step in highlighting the importance of state courts.
And Anita, can you just talk briefly about how to hold those judges accountable, and especially in terms of how they're elected?
Well, I think that it goes back to the benefits of having more attention, public attention to the state court decision-making process. So if there are ways that seem less proper in terms of threatening judges if you're in power in the legislature, but I do think that judges care somewhat about what the media says about them, and if the public is outraged about, I mean, it's hard to do before the fact, but I think after the fact, if the public is outraged about a way in which a judicial decision just has not seemed to be fair, that will have some impact.
Do either of you guys have any points you want to make before I open it for questions? Okay, so let's open it for questions. As the standard disclaimer, please ask a question, not give a statement, but I know there's a lot of really brilliant people in the room, so we want to hear from you as well. So if you have a question, Katie, do you want to circulate note cards or anything, or should people just stand up and ask questions? Okay, just stand up if you want to ask a question, and we'll get you a mic. Anybody? That's not possible.
Don't be shy. There we go.
No. 2 seconds.
Hi, I'm Franita McDonald, and I'm an attorney in town here. I have a question.
The mic is off.
It's okay, I can speak louder. Is this better?
I think it's on now.
It's Franita McDonald. I'm an attorney in town, and I thank you for this symposium. It's been very interesting. I have a question for Anita. When you were able to prove intent, that this specific restriction was intended for the students in the area, can you go into a little more of how you went about improving that intent?
Right, and I think that's a really great question, because it sort of highlights federal litigation is really costly, and the procedures are more involved and detailed. In state court, this was a very quick administrative review of a state board decision, so it wasn't as, the litigation was easier to streamline and make fast. There was one hearing. There weren't months and months of depositions of witnesses, and there was a record of how that local board had made that decision, and evidence from students about the difficulties. They had put their early voting site in a place that you couldn't reach by bus, that there was no parking for, down a road that there was not even a sidewalk. So the facts were pretty egregious, and that was enough to convince the judge. So that's an example of where state court judges are more willing to just look at what's going on and make their call about it.
Up in the front.
The question about what are voter IDs.
Just wait 1 second, because I'm not sure.
I have a question about voter IDs. In the state of Georgia, I'm not so familiar with other states, you have to show a government-issued ID, which often is a driver's license. And in order to get a driver's license, when you renew your driver's license, in Georgia you have to show some proof of your identity. And often, people's birth certificates will not be the same name with which they've used over many years, therefore they don't get a driver's license. And they have to apply to a superior court for a name change, which often takes 6 months to a year. And is there any litigation about that? And people are often discouraged from voting because they don't have that.
If I can, and Dale, I know Dale will want to answer too, but I would commend to you the district court opinion in the Texas voter ID case, which is now being appealed to the Fifth Circuit, but there is excellent testimony there of exactly what you're talking about. Those facts were brought forward in very good detail, the stories of all the different ways, whether it's because voters are disabled, whether it's because their names changed, all the different reasons why their documents might not match their voter registration, and the judge credited that evidence and found that Texas's voter ID law was unconstitutional because it unconstitutionally burdened the right to vote. So the judge went into this balancing test of how much of a burden is it on the voter versus how much was the law needed. And so not even a race-based test, but just, is it a burden? And the judge found, there's only been 2 instances of in-person fraud in Texas in the past 10 years, and then here's all these voters coming into court testifying about the burdens on them. So they also found it to be racially discriminatory and intentionally racially discriminatory based on some testimony of legislators as well. But I think that district court opinion is a really good roadmap for how the considerations you're talking about were proven in court.
I mean, the issue that you're talking about is something that I think all of us who've been working on these kinds of cases have been seeing. So the lead plaintiff, for instance, in the Wisconsin federal litigation challenging Wisconsin's ID law was a woman in her 80s who was born at home, never got a birth certificate. She had a baptismal certificate, but it had her maiden name on it, right? That was the only document that she had, and she couldn't get an ID. Now, it was pretty remarkable because she was an elected member of her village board, right? So she was faced with the prospect of not being able to vote for herself in the upcoming election. She's no longer in office now, but I mean, she still has no ID. If the Wisconsin ID law goes back online, she's out.
Hi, I'm Jeremy Ferris at Bonner, Nixon and Elmore. I want to ask kind of a conceptually converse question to the topic that the panel's been addressing, and that's namely, after Shelby County looking to intertribal council and the preemption clause analysis that the Supreme Court has provided with respect to Article 1, Section 4 as an opportunity to think about other federal statutes other than the Voting Rights Act as ways to establish a floor for voting rights in states that, like Georgia, might have courts that are outcome determinative in a way that we might not like. So, for example, in the Help America Vote Act, with respect to voter ID, the Help America Vote Act has a provision that says for voters to register by mail, they have to show ID, but not necessarily photo ID. And I was wondering if the panel had encountered this provision or any other provisions of other federal statutes other than the Voting Rights Act that might be used after intertribal council to establish floors for states like Georgia and other states in the South that might be less hospitable to state court claims.
So, okay. The interesting thing is that the intertribal council decision, in my opinion, has kind of had the opposite effect. So Kansas and Arizona they want to do proof of citizenship requirements for voter registration, and their desire to do so was the basis of the intertribal council decision. But the interesting thing is that what it has done is encourage states to run parallel voter registration systems, which I think is a bad thing, because the article, let me see how good I am. The Elections Clause of Article 1, Section 4, yes, basically says that states shall set the time, place, and manner of elections for representatives, subject to Congress's authority to override those regulations if Congress sees fit. But the interesting thing about that is that it only applies to federal elections, so it'll only get you so far. So because of that, even though Congress has broad authority under that clause to regulate, it doesn't really cover situations where the state is also trying to run state elections. And so one way Arizona and Kansas has gotten around this is by trying to run parallel voter registration systems. But there's recently the 10th Circuit, so the lower court I'm trying to have so many decisions swimming in my head. The lower court had found that the Election Administration Council, the EAC, had to allow the states to use proof of citizenship as a part of their voter registration form under the National Voter Registration Act. The 10th Circuit reversed that. So we'll see what happens, but conceivably we could end up with a situation where if a state wants to have more restrictive regulations, then they just separate out the systems. So I haven't really seen intertribal being used in like a positive way. You would think that because Congress has this expansive authority under the Elections Clause, then perhaps this lays the foundation for looking to other federal laws to regulate the right to vote, but I haven't really seen that. And in fact, the decision has kind of raised some concerns, because one thing that the decision does is it limits Congress's ability to directly regulate voter qualifications. And so I think that aspect of the decision, given the current composition of the Supreme Court, raises some concerns going forward, because you can see future decisions where the court actually comes in and says that Congress is limited in its ability to directly regulate voter qualifications, and then citing to Arizona Intertribal. So although the decision looks positive initially, because the decision basically lays the foundation for a broad congressional power, at the end of the day, there's language in there that's very concerned about limiting the scope of federal authority to regulate voter qualifications, and possibly allowing states to run these parallel systems.
If I could just add something to that, because I agree with Franita about the concerns that I think the Arizona decision raises. The problem, I think, is that the Elections Clause power that you're referring to obviously extends only to Congress's ability to regulate federal elections, right? And in less charged partisan times, that would have been sufficient, right? When the National Voter Registration Act was passed in the 90s, Congress was specifically only trying to, consistent with its authority, regulate registration for federal elections. But what Congress understood was that states weren't going to want to go through the hassle and trouble of setting up two different systems of registration, one for federal and one for state. So once the federal government set the ground rules for registering for federal elections, that would have a trickle effect to state elections. That, unfortunately, is no longer the case right now, right? Things have become so charged and so partisan that when the federal government says, okay, these are the regulations we're going to have for federal elections, you have states like Arizona and Kansas saying, fine, you use the federal voter registration form to register to vote, you can vote for president, but you can't vote for governor, right? Because that's a state election, right? And we can do what we can try to do in terms of federal legislation here, but until we get back to the point where, we have a broader consensus that we shouldn't be making voting harder, states are still going to throw up obstacles with these dual registration systems.
But just as a rejoinder, wouldn't there be a congressional election, a federal congressional election happening concurrent with the gubernatorial election?
Right, so what Kansas is actually doing is if you use the federal voter registration form to vote and didn't comply with the other requirements of the state voter registration procedures, they'll give you a ballot that only has the federal offices on it, and you can't vote for the state offices, right? So we know that you're a qualified elector to vote for president. We trust that. We just don't know if you're qualified to vote for dog catcher.
Other questions?
Hey there, my name is Adam Sparks. I'm an attorney here in town, and thank you all for being here today. Really appreciate all the expertise. I wanted to build some on the concern about the hyper-partisan environment that keeps coming up. This isn't the first time that lawyers have had to turn to state constitutional provisions over federal provisions. The school finance litigators, for example, had to do so in the 70s after other U.S. and military candidates also success in state constitutional provisions. I wonder, one of the advocacy techniques that was useful in that arena was the use of sort of public shaming. If you look at some of the cases where you were able to get criticisms out of the state courts of last resort, the advocates were often comparing sort of what other states have done in terms of financing schools in a more equitable manner and forcing legislatures to actually take positive steps to ensure greater opportunity for students. And that seemed to have an effect both in the public mind and also in the courts themselves. If these state constitutional provisions regarding the right to vote are in fact functionally equivalent across different states, it's going to sound a little strange, but what role does public shame actually have in keeping these judges accountable? Or is it such a toxic environment at this point that we simply have to wait it out, wait for more rational, reasonable, if your advocate minds to prevail as a form of advocacy? So what role does public shame play in advocacy and argument in this arena?
Well, I would say that it's actually a public affirmation of our democratic values, that's what we're doing. When we say that, either a state law or a local practice or a local interpretation of a state law is barring people from being able to vote, or is intentionally making it harder for them to vote rather than making it easier to vote. We're really standing up for what our democracy means. And so I think it's crucial to be able to do that and to have the resources to do that, and that it involves working with the media, working with communities. The case that I just described where the judge was willing to say this discriminates against students, there was a lot of media attention to that case, and it was featured on MSNBC, and the local folks, were in the media trying to, falling all over themselves trying to explain why this decision they made that made no sense. So I think you absolutely hit the nail on the head that that's got to be part of the strategy.
I want to ask one other question to the panel. Tomorrow, the Supreme Court's going to decide whether to hear the Wisconsin voter ID case, and if they decide to hear the case, it's going to be the first time that the court will hear a case on the merits about voter ID laws since the Indiana case upholding that voter ID law in 2008. Obviously, a lot has changed in the debate over voter ID laws. Since then, Judge Posner, who upheld Indiana's voter ID law in 2008 at the Court of Appeals, has essentially disavowed his opinion and wrote a really scathing opinion about the Wisconsin voter ID law last year. So can someone on this panel, maybe a few people on the panel, talk about if the Supreme Court was to hear the Wisconsin voter ID decision, what the issues would be and what the ramifications would be? I know that we're talking federal now instead of state, but it seems like this could impact a lot of different things.
Sure, I can talk a little bit about it. So as Ari mentioned, it's conferenced for tomorrow. It's calendared for the Supreme Court's conference tomorrow. We could hear on Monday whether or not the Supreme Court is going to take the case. Now, the Supreme Court actually doesn't have to decide. Tomorrow they could decide that they want to take more time and think about it more. They could decide to ask for the views of the Solicitor General before proceeding. So we could hear on Monday whether or not the court is taking the case, but there may not in fact be a decision. So what are the issues in this case, and how does it differ from the Crawford case where the Supreme Court sustained Indiana's voter ID law? The first is with respect to the record, right? The lead opinion in the Crawford case held that there was insufficient evidence in the record to determine the magnitude and extent of the burden on voters who would be potentially disenfranchised by the Indiana voter ID law. That is, there was no evidence in the record in Indiana as to how many voters in Indiana lack ID. There was no evidence in the record as to what kinds of barriers those voters would have to overcome in order to obtain ID. The plaintiffs proceeded on a preliminary injunction in that case, really based on just the bare fact that to get an ID in Indiana, you need a birth certificate, and for most people, a birth certificate costs money to obtain, and then you have to travel somewhere to get that ID. But they didn't have actual living, breathing voters who could attest to what that actually would mean for them, right? In Wisconsin, the record is, as one of the dissenting judges on one of the rehearing motions we put it, is different in every way, right? We have a record as to how many voters in Wisconsin don't have this ID. The trial judge found 10% of voters, of registered voters in Wisconsin don't have one of these IDs. That's 300,000 voters in Wisconsin. We had dozens of people come in and testify that they were either completely unable to obtain ID after months of efforts, or were only able to do so with substantial assistance from either legal organizations, relatives, or personal connections within the government, right? So it's a very, very different record. So the question, I think, that will be posed to the court is whether or not, on a record like that, the state's mere assertion of trying to prevent voter impersonation without any evidence that that ever has actually happened in the state is going to be sufficient to sustain this kind of restriction on a constitutional challenge. That's the first issue. The second issue is whether or not these laws pass muster under Section 2 of the Voting Rights Act, which was not an issue presented in the Crawford case, but was squarely presented in this case.
I will say that I hope that in the years since Cropper, there has been some realization that every voter identification law is not the same. So we didn't really have a conversation about this back in 2008. But as states have passed more restrictive laws in the intervening years, I think it's become clear that some voter identification laws are more restrictive than others. And perhaps this is something that the court should take into consideration, particularly if they apply the verdict balance and very deferential framework. In trying to assess the burden on voters. I think that it matters. For example, Texas's law is much more restrictive than the law in South Carolina, for example. And let me just add, the law in South Carolina, one reason why it's not as restrictive is because of negotiations between the Department of Justice and the state through the Section 5 pre-clearance mechanism, something that we don't have anymore. So I just think that, there's hopefully is some realization by the court if they do decide to hear this case that every voter identification law is not the same, even if they're inclined to say that states can pass voter identification laws.
Anita, the case you're working on in North Carolina will also come before the Supreme Court, potentially down the road. What is your view of that? Do you want the Supreme Court to weigh in on some of these cases, or do you basically just want to play keep away given the Shelby decision?
Well, in the challenge to North Carolina's restrictive law, I think we're optimistic, believe it or not, about the Fourth Circuit. For a long time, it was like the curse to be a lawyer litigating in the Fourth Circuit, but that's one circuit where there have been enough appointments that there's actually balance. And you can argue a voting rights case in front of a panel that has some ability to understand your client's situation. I think that the Supreme Court litigators that I talk to say that this court is out to restrict the rights of people of color as fast as they can, as much as they can, as long as they can. So I take that seriously when they say that. That's all I can say about that.
Any other questions? One more question.
Thank you. I'm William Perry with Common Cause Georgia, and I was actually a stay-at-home dad for 7 years during the whole Georgia ID battle, and because it wasn't an issue that Word Girl took on, it really wasn't something that I could follow. So it'd been my understanding that the plaintiff in the case couldn't find a single person in Georgia that would step forward and say, I couldn't vote because I couldn't obtain ID. So first of all, I wanted to know if that is in fact the case, and then if it is, then how do you argue, I guess, the hypothetical in that situation that it's truly suppressing somebody from being able to vote?
Can we get Lachlan to talk about this for a second?
I think Neil Bradley's the guy that...
Okay.
No, we had plaintiffs.
Stand up, Neil.
That's all right. We had plaintiffs. One of them dropped out from intimidation early on. The judge made a very nice comment about how precious the right to vote is and how easily it can be lost by intimidation. We had a second plaintiff, who might have been more capable, but the argument was if you got this person to come from Savannah to Rome, Georgia for a trial, he can get an ID if he has those kind of resources. Of course, we got him from Savannah to Rome. But that's the answer to your question.
I will just add on the, go ahead.
If I could just add, that person you got from Savannah was my grandfather. My name is Francis Johnson, and I'm the president of the Georgia NAACP. And he was without ID. He lived on a farm for 96 years. He's still alive, 100 years old. Never had need for an ID. Operated his farm without the necessity of a driver's license. Georgia law provides for that, and had voted in every election and would be prohibited from voting in this case. So to the initial question, that is not true. And there are many, many other individuals like that who were either born and had their livelihood on a farm, or were born to midwives during the time when there were segregated hospitals, often have problems and complications getting birth certificates today because of mistranslations on those midwife records, and they're working through that now, even trying to get a proper ID. So I do think it's a smaller and smaller percentage of the problem, but it's still an enormous task, especially in rural Georgia.
I will add that in the Georgia case, this was submitted to the federal government, and the Section 5 review team working on it, 4 out of 5 members of them said that it would disproportionately hurt people of color and urged that it be rejected by the federal government, but the Bush Civil Rights Division overruled their staff and cleared that law, which then set a very bad precedent for voter ID laws in the future. Also, the courts initially found that that law was a poll tax, and then the procedures for obtaining ID were relaxed, and then it was upheld. So there's some complicated issues regarding the Georgia case that I think are important to mention. I think we will leave it there, but I want to give all the panelists a quick chance to plug anything they're working on. What are you working on? Where can people find your work? And what can people in this room do to help you? We'll start with Dale.
I just want to pick up on something that Tom mentioned in his opening remarks about how a Republican form of government type argument could not only serve as a shield, but also as a sword for expanding access, and how we could maybe model that in state court litigation too, right? Because if state constitutions guarantee an explicit right to vote, then there's maybe no reason why we can't use that provision to not just prevent these kind of suppressive measures, but also try to make voting easier. Our New Jersey affiliate, for instance, has brought litigation not challenging the elimination of same-day registration, which I think I alluded to earlier, something that's really, really valuable, but actually to require New Jersey to implement it. Because under the New Jersey Constitution, any eligible voter is able to cast a ballot. There's no requirement of registration under the New Jersey State Constitution. The only rationale that the state has given in the past was the need to update its administrative records, but now the technology exists whereby that can be done instantaneously, and New Jersey no longer has any rationale for that. And an intermediate appellate court actually agreed that we had a good claim there and sent it to the trial court for some fact-finding. So maybe there are great opportunities to use state courts, not just defensively, but also to expand access.
So my work is on my SSRM page. I have a tricky name, Franita Tolson. But I will say that one thing I do want to plug is that, and this alludes to a question from earlier about opportunities that are open in the wake of Shelby County. Use some of my stuff. I'm weird. I argue weird things, but it can work. If you look at some of the litigation surrounding the Affordable Care Act, there are law professors working in their offices coming up with these weird litigation strategies, making it all the way to the Supreme Court. So I'm encouraging you, get away from the tried and true, try some new stuff, Section 2 of the 14th Amendment, Article 1, Section 2, it could work. We can do this, call me.
So as Katie mentioned earlier, I have a book coming out the first week of August on the history of voting rights since 1965 that is called Give Us the Ballot, and it will be published on the 50th anniversary of the signing of the Voting Rights Act. And what I'm trying to do in my work in terms of the coverage of voting rights is to tell the story of what happened after March 1965, because I think so much of the discussion of the Voting Rights Act, and even the film Selma, as great as it is, it ends in 65 with the Voting Rights Act as the climax of the civil rights movement. And we've had 50 years since then, and voting rights, as we know, are under attack today. So I'm trying to tell the story of what happened after the VRA so people can learn that this isn't just history, right? We're living it all over again. And so I hope that I can talk to many of you about this come August, and I'm happy to talk to you before that. And I'm on Twitter at Ari Berman, and I'm at thenation.com if you want to read my writing. Josh?
So after you call Franita, she'll probably give you some great advice, and one of the things she might say is, we'll call Josh as well, because we end up often on phone calls together, or someone calls me and said, well, I just talked to Franita Tolson, and vice versa. I think she's right that there is a lot of great ideas out there, things that are a little unconventional. We've talked a little bit about a couple of my articles. One, the right to vote under state constitutions, which is in the Vanderbilt Law Review, I think makes an interesting argument because it's one that should appeal to conservatives and Republicans, the primacy of their state documents. This forthcoming article, not yet placed, called State Judges and the Right to Vote, is a follow-up. You can find it on SSRN, which is the Social Science Research Network. And then I think it's important that law professors engage with advocacy organizations, with people like Dale and Anita, and others who are doing great work. Things like proposing constitutional amendments to state constitutions that expand the right to vote even further in those states is another idea, and something that both Franita and I have been looking into. There's opportunities for lots of different areas, and I do think that a grassroots movement at the state level, it takes a long time because you have to go state by state, but ultimately can have a national impact.
So the Southern Coalition for Social Justice is a regional organization. We have co-counseled on cases in Georgia, and so my request is that if you're interested at all in litigating any of these cases, or if you learn of an issue where you live, to contact us. We're building or trying to facilitate a network of regional advocates called SOLVE, Southern Leaders for Voter Engagement. So we have a listserv. It's not that active, but it's a way to hear about when problems come up, and I can add you to that listserv. They're activists, and we're really trying to be multi-generational, so young folks as well as people who have been doing this work for 30 years around the South. We've actually met once in Atlanta before. And the goal is to have a regional collaboration around the barriers that people are facing, and then what creative strategies to advocate, really to enfranchise everyone, and access to legal advice and representation is a huge need, right? There just aren't enough of us doing this work to go around, so that's my call to arms.
Thank you, everyone. This has been terrific.